What do a smartphone, a company logo, and a best-selling book all have in common? Give up? They're all examples of intellectual property. Think about what that means. Intellectual property. Intellectual, products from your intellect. Property, things you own. So intellectual property are things you own that come out of your mind. Now, that's a pretty powerful concept, isn't it? And that concept is one of the most important aspects of what drives our capitalist system. Without the ability to protect intellectual property, entrepreneurs wouldn't have as much incentive to create some of the groundbreaking products and services that they do. After all, why would I invest a lot of time and money into developing something if someone else could just copy it? Fortunately, our government recognizes this possibility and affords us the opportunity to receive the awards for our own ingenuity. The U.S. Constitution protects your rights to have and own original ideas for products, logos, images, and creative work. Section 8 of Article 1 of the U.S. Constitution reads, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors exclusive rights to their respective writings and discoveries." Now, it's not a perfect system. The interpretation of the law evolves over time, and a lot of money is spent arguing cases in court. But there's no doubt that the intellectual property system has spurred innovation. If you don't believe that, compare the innovation in countries that respect intellectual property with those that don't. The contrast is startling. Sure, some places might profit from ripping off customers with pirated goods, but great fortunes are rarely made this way. Because to build true wealth with legal products that customers want, you have to be accepted into the larger global economy. Just as civil rights and democracy took time to be adopted around the world, intellectual property rights did that too. And as more countries embrace capitalism as a way to increase prosperity, intellectual property rights are increasingly becoming more common around the world. And that's a really good thing. So, if you want to be a player in the business world today, you need to understand how intellectual property works. As a university professor, I can tell you that anytime I share one of my students' ideas with potential investors, they get a lot more excited when they find out that there's a patent involved. You see, it brings an air of legitimacy and seriousness to the discussion. And I get the sense the investor gives the idea an increased market value automatically because a patent adds a barrier of entry to possible competitors. Now, it doesn't mean the idea is going to be a hit or that rival products won't happen, but it does get the attention of the investor. They want to take a further look at what my student is trying to do. In today's lecture, I'm going to share with you how you can protect your ideas. We'll cover the 3 basic types of intellectual property: patents, trademarks, and copyrights. So, let's get started by looking at patents. Let's assume that you have an idea for a new product, technology, or service. What are your first steps? You might think that you can get a good idea of what's patented by scouring the shelves of stores. Well, that's a dangerous approach, because only 4% of what's patented enters commerce as a product or service. Now, this is a very important point to remember. Just because a product's not on the shelves at Walmart doesn't mean it doesn't have a patent or that one doesn't exist. After all, there are more than 8 million patents in existence. And if you go to market with something that's already patented, you could find yourself in a very nasty lawsuit. No one wants that. So, the first thing that I recommend you do to prevent a legal disaster is to search the existent patent databases for similar products and technology. This is important for a few reasons. First of all, you want to see if anyone's already worked on the same idea that you have. You don't want to put a lot of time and effort into something that you later find already exists. But even if it does exist, that doesn't mean you're out of the game, because you might be able to look at what someone else has already filed and learn from their work. After all, A patent is public information. Someone else has already put a lot of thought into the technology, and those ideas might serve as a lesson for how you can create your own product. A patent can also give you ideas for improving what's already on the market. By looking at other companies' patents, you can find the weaknesses in their designs and come up with ideas for a better product. In a sense, when a competitor files a patent, they're releasing their product's playbook out into the world. Let me give you an example from a product you're all probably familiar with, the iPad. The iPad was released by Apple on April 3, 2010. As was common practice at Apple, Steve Jobs held a keynote presentation to introduce the product to the world. It was a truly revolutionary product and unlike anything anyone had ever seen before. Well, almost anyone. Because if you were looking real close into the patents filed with the USPTO, you might have found hints of it years before it even came out on the market. Patent number D504889 was filed by Apple in March 2004. That's right, 6 years before its release. In the pictures included in the patent, you'll see figures using a now familiar product in a now familiar way. The pictures show a rectangular tablet computer, and some even show it in use. One particular picture shows a man touching the screen with his finger on what seems to be a shiny glass screen. So, what does that patent mean for you as an entrepreneur? Well, if you were planning on competing in the tablet computer market, it would have given you hints of what's coming down the pike. You could actually strategize from that information where you might want to place yourself in the market. Where could you differentiate yourself from that Apple product? What could you have done differently? Or better yet, an entrepreneur could think about how to coexist with that new product. For example, what supporting accessories could be developed to go with the new tablet computer? Perhaps the new product would need a protective case or a small carrying bag. Now, you might not be able to fully understand what the product is because a lot of the design is captured among many new patents. How Apple actually put together the iPad was very secretive. Plus, many of the components used in the device were patented by other companies besides Apple that the company later licensed or purchased outright. But still, there are harbingers in the patents of what is to come. Okay, now, that's all good information about what patents can do for the entrepreneur. But you're probably wondering how to find these patents in the first place. Now, that doesn't sound very easy, does it? I mean, there are millions of patents on file with the U.S. government. How do you discover if a patent already exists for your product? Well, the tools for finding out if a patent already exists for your invention lay at your fingertips. In fact, let's add this skill to your toolkit. Research existing patents. You want to see if you can find patents out there that are similar to yours, because this is really important. And to do this, you can search website databases on your computer and do a fairly thorough search. One handy website you can use is Google Patents at google.com/patents. You can find the essential elements of any patent in Google Patents, and it's also formatted with easy user interfaces. It's like a Google search for patents. And in fact, I go there quite often for my first run whenever I look for a patent. But the granddaddy website of patents is the official government website. The U.S. Patent and Trademark Office, also known as the USPTO, is the official agency that reviews, grants, and posts patents. Its website can be found at uspto.gov. The Google and USPTO websites are wonderful services because you can search at no charge to determine if an invention or line of research has already been patented. Catching patents early is a big deal because the patent process can be very expensive. The patent process tends to cost, at a minimum, $8,000 to $15,000. But don't be surprised if it ends up costing a lot more. Now, we'll discuss the financial side of patents more when we think about how to get help from patent attorneys. But let's next turn to a little more detail about what a patent actually is. Because understanding what a patent is will help you determine if you need one. The government provides guidelines for us to make it a little bit easier. In a provision in Title 35 of the United States Code, we find two requirements of what can be patentable. First, the invention must be a new and useful process, machine, item of manufacture, or composition. Now, this sounds pretty straightforward, doesn't it? But unfortunately, it's not, because legal wrangling oftentimes comes into play. Look at the very simple but very vague words, new and useful. New and useful. What makes an invention new? Well, it needs to be different from what's already patented. But how different does something have to be considered new? That's where the USPTO comes into play again. Patent examiners sift through existing records to see how the proposed invention fits into the current state of the world. You have to be able to make your case in your patent filing that your invention is indeed new. And one important aspect of doing this is that you refer to already existing patents that are in your invention space. You have to cite what already exists and then explain how yours is different. The government's patent office is staffed with some very knowledgeable and very skilled professionals. And you better believe if you don't address what exists, they will. You have to make your case to the USPTO. Now, let's think about the second vague word, useful. Who determines if it's useful? Well, that examiner does. You have to make the case that the invention has a practical application in the real world. If it's too fantasy-based, or if it's impractical, the patent won't be granted. Let's read that patent requirement again. The invention must be a new and useful process, machine, item of manufacture, or composition. On first reading that, it kind of seems pretty straightforward. But now we can see that it's really not. That's why I cannot emphasize enough that if you're thinking about filing for a patent, please hire a good intellectual property attorney. A good IP attorney worth their salt has seen just about every type of patent that you can imagine. They'll also have a good idea of not only whether your invention is new and useful, but also how to write that patent in a way that the examiner will think is very good too. Okay, so that's one requirement of a patent. The second requirement of your invention that has to be met to get a patent is that it must be non-obvious and reproducible by one skilled in the art. Again, that sounds pretty straightforward. Non-obvious and reproducible. And again, it's not as simple as it sounds. Let's think about it. Non-obvious? This means that you have to prove that some original thought went into coming up with that idea. The invention has to be one that's different than what others would come up with if they had thought about it. There has to kind of be that aha quality to make that idea special. And it has to be reproducible by one skilled in the art. So you have to be able to explain how the invention can be reasonably manufactured. The government isn't going to grant a patent to an idea that's way ahead of its time. For example, if science and industry doesn't understand how to move particles through wormholes in space, don't expect to be granted a patent for your machine that can zap you from Mars in a second. Now, if you can create a rocket that recycles currently known energy sources, that's going to be a different story. And Elon Musk, the founder of PayPal and Tesla Motors, is currently doing just that with SpaceX. Musk is working on inventing rockets to transport people to Mars in the next 25 years. And you better believe he's filing many patents to ensure that he's the one that gets the right to do that. SpaceX was working on non-obvious and reproducible versions of rockets that will hopefully get you to Mars. And again, what makes something non-obvious and reproducible is up for debate. Now, these two basic requirements, new and useful and non-obvious and reproducible, have to be met to get a patent. So if you're considering getting a patent for your business, I'd suggest adding this to our toolkit. Create a case for your patent. The way you do this is to sit down and write an argument that addresses these questions. Here's the questions. How is your product or invention new and useful, and how is it non-obvious and reproducible? Even though I'd still suggest getting a patent attorney, this is a great thing to start thinking about now. But now it gets a little more complex because there are also different types of patents that can be filed. There are utility patents, design patents, and plant patents. Now, I'm going to explain what all three of these types of patents mean, but here's another thing you'll want to add to your toolkit. Understand what type of patent you need. So let me describe each, but as I'm doing so, think about what type of patent you'll need for your invention. Let's take utility patents first. What exactly are they? Well, utility patents are what we often think about when we hear the word patent. They protect how something works, and there are generally 4 types of utility patents. The first is chemical compositions. So this would be something like toothpaste. And you better believe that consumer goods companies like Procter & Gamble have many patents like this. A second type of utility patent is called articles of manufacture. This would be products as you normally imagine them: smartphones, tennis balls, skis, etc. You can also patent machines. So many machines that are used to make chemical compositions and articles of manufacture can actually be patented. And the fourth utility patent covers processes. You'll often find data storage systems fitting into this category. If you get a utility patent, you have exclusive rights to that invention for 20 years from the date of filing. A second type of patent is called a design patent. Design patents cover how something looks. Yes, that's right. You can patent different shapes and details on products. These patents last for 14 years. One of the most famous design patents is officially titled D48-160. You might know that design better as the very recognizable Coca-Cola bottle. This design patent ensures that the bulging midsection of the bottle and the flowing flutes down the side are the sole appearance of the Coke drink. All right, other famous design patents are often found in toys like Lego bricks and games like Monopoly. And if you want to see some really neat design patents, check out the auto industry. There are iconic designs like the Porsche 911 and the Volkswagen Beetle, which are protected by patents as well. One lesson here is that if you can create a unique ornamental look for a product, you can file a patent and protect it. But another lesson is that if you like the look of a competitor's product, you better think twice before you copy it, because it might just be protected by a patent, so you better do a patent search before you make it. And the third type of patent covers plants. Now, this might surprise you, but many of the flowers that you buy and the foods that you eat are actually engineered by companies. They didn't exist in nature until scientists came up with them. When this is done, companies like Monsanto, they can actually file for patents and the exclusive right to provide those plants. So, that's the type of patents you can apply for. 8 million patents seem to cover a lot of things we see out in the world, but not everything qualifies for a patent. So, what doesn't qualify for a patent? Well, first of all, an idea alone isn't patentable. You have to actually be able to explain in detail how to bring the invention out into the world. So, Elon Musk can't patent the idea of a rocket that will get to Mars. He has to actually explain how the rocket will make it possible to get to Mars. And laws of nature aren't patentable either. Just because you make a breakthrough discovery of some phenomena that no one's ever seen before doesn't mean you own it. When James Watson, Francis Crick, and Maurice Wilkins discovered the structure of DNA, that did not give them the rights to your genes or my genes. That relates to the third thing that can't be patented: scientific principles. gaining understanding of how the universe works doesn't guarantee you the right to keep that knowledge from others. And the fourth type of thing that can't be patented are methods of doing business. Although you can patent new digital tools for online business and commerce, you can't patent general ways of competing in markets. For example, Sam Walton couldn't patent his supply chain strategy for creating thousands of big box retail stores. Other companies are free to copy Walmart's model, but they'll still probably have a pretty hard time pulling it off. Another important aspect of patents that you need to understand is that patents are becoming more recognized around the world. More industrialized countries offer inventors protection in the form of a patent, although the standards may vary from country to country. But the accepted wisdom is that if an invention has been patented in one country, it can't be patented in another because it's already been patented out in the world. And while it's complex, international IP law is getting smoother every year. There's international treaties that allow U.S. inventors to obtain patent protection in other countries if they take certain required steps. You can go to the World Intellectual Property Organization's website at wipo.int to find out more about those steps. And you can visit the European Union's website at worldwide.espacenet.com to search for foreign patents as well. Now, let's say you do a search and that search comes up empty. In this situation, you'll want to consider whether you should file for your own. Again, I recommend you hire a competent intellectual property attorney because filing a patent is a complicated bureaucratic venture. And you better be prepared to wait a while because before you get it granted, it can typically take a year and a half, sometimes even 2 years from the date of filing to be awarded that patent. But that doesn't mean you have to wait to be awarded a patent before you start making your product. When you file, you can classify your invention as patent pending, and you can keep working away on it. That is, of course, if someone else doesn't already have a patent on that invention. A good IP attorney can make sure you make the right decisions about how you time your production and protect your ideas. They can also advise you as to whether an invention should even be patented. And I want you to be aware that the government is constantly switching up what you have to go through to get a patent. New laws are making filing a patent trickier than ever. They're always coming up. Old patent laws followed a first-to-invent philosophy. And this meant that the company that could show evidence that they came up with an invention first was granted a patent on it. So, if a competing company filed before you did, and you brought forth testimony, media sources, and product notes showing that you had the idea first, you still got a word of the patent. Not the case anymore, because now the government is following a first-to-file philosophy. This means the first company to file a patent, they get it. Now, that's a tricky decision because you might not have the invention fully working yet when you need to file. After all, you may not even be sure if the invention is a good idea or whether it needs to be polished. If it's not a good idea, you might waste a lot of money on something that doesn't pan out. But then again, if you don't file and it is a good idea, someone could scoop it up and they could beat you to market. Once again, a trusty IP attorney can be a great resource for making this call. As I mentioned earlier, filing a patent isn't cheap. It costs at least $8,000 to $15,000 to go through the patent process, and it's very common to see an entrepreneur spend $30,000 on a patent. But the costs don't stop there, because let's say that you have a patent that gives you the right to exclusively sell a product. What happens if someone tries to rip you off? Well, the obvious answer is that you're going to have to sue them. And that doesn't come free. You have to pay your IP attorney to take the offending company to court. And if the court decides the other company didn't violate the patent, you're out all that money. So, is it worth getting a patent? Well, a lot of times it is, but really most times it's not. The fact is that not every new invention needs patent protection. What often determines success in business comes down to who gets to market first. Execution, not legalities, is often what determines success or failure for most companies. But there's another type of intellectual property that comes in handy when you go to market, and that's trademarks. Trademarks are names or logos that you see for companies, products, and services. More specifically, a provision in Title 15 of the U.S. Code states that trademarks are any word, name, symbol, or device that identifies the goods or services of one entity from the goods or services of another in interstate commerce. So, what this law is saying is that you can file for exclusive trademark protection on a logo or name throughout the country. You can search the USPTO website for trademarks too. If you file for a trademark and get granted one, your logo or name is given the symbol TM to go with it. Filing a trademark is pretty easy and not nearly as costly as the patent process. So, let's say you've invented a new type of dog toy. You might consider giving it a catchy name and getting a first production run of it made. In the meantime, you file a provisional patent application that is fairly cheap and it secures your recognition as the first to file. You then have 12 months to file the more official patent application. In that time, you can see how the market responds to your new product. Now, if it seems to be doing pretty well, you should probably consider filing the full patent. And if it isn't doing well, you can cut your losses and move on to the next idea. And you'd be amazed at all the things that are trademarked. Not only are logos and company names viable items to be trademarked, catchphrases, slogans, and taglines are all fair game. For example, the NBA basketball coach Pat Riley made a small fortune when he trademarked the catchphrase, "Three-peat." I've heard that in the news quite a bit with Miami Heat lately. Every time that catchphrase is put on a t-shirt, Pat Riley gets a royalty on it. That's not too bad. So, if you think you've come up with a really neat product, think about how you can come up with a catchy name that customers are going to remember. A trademark can be an excellent tool for setting you apart from your competition. But it's also important to know that unlike a patent, you can have exclusive rights to a trademark forever, as long as you continue to pay the government its registration fees. One other very commonly used intellectual property tool is the copyright. A provision in Title 17 of the U.S. Code provides protection for creative products. When you hear the word copyright, you tend to think of books and movies, and those do fit under copyright laws. But more specifically, the government states that it grants automatic protection to printed works, software, artwork, photos, video, and practically everything on the internet once it is fixed in any tangible medium of expression. You can register for more protection with the U.S. Copyright Office at copyright.gov. The duration of protection for a copyrighted item is 70 years. Now, after that, the copyrighted work goes into the public domain and it's free for everyone to get access to. Now, patents, trademarks, and copyrights are all tools an entrepreneur can file with the government to be given exclusive rights to sell their creations. Now, that sounds like a pretty good thing, and it usually is, but a lot of companies choose to not take this route, especially when it comes to patents. Now, why would that be? Well, because patents are publicly disclosed documents about what your product is made of. Maybe they'd rather not let others know how they make their product. When a company comes up with a method for doing something and they want to keep it secret from others, this is called a trade secret. Think about the secret formulas for Coca-Cola and Kentucky Fried Chicken. These are both trade secrets. Now, unlike a patent, you don't file for a trade secret, you fight to protect a trade secret. This takes a lot of discipline on the part of the company taking this strategy. In order to be recognized as having a trade secret, the company has to let everyone on the inside know that there are swift legal consequences if the secret is revealed. So, the secret has to be guarded, and only those what they need to know will have access to that knowledge. There has to be a strategy in place for a trade secret to remain secret. And if another company copies a competitor's trade secret and it can be shown that it was done through underhanded methods, a lawsuit can take place. When a company infringes on another company's trade secret, the damages can be in the millions of dollars. And while patents can give a company exclusive rights to sell something for 17 years, trade secrets can be forever. Okay, in today's lecture, we looked at intellectual property and we added 3 new tools to our toolkit. Here they are again. Research existing patents. Create a case for your patent and understand what type of patent you need. Intellectual property is a complicated topic, but it's one every entrepreneur should become familiar with. If you can gain a basic understanding of how patents, trademarks, copyrights, and trade secrets work, you'll have some good grounding for being prepared for the challenges that come up with IP. To be fully prepared for those challenges, I recommend that you find a solid intellectual property attorney who can give you great advice. It may cost you a little bit in the short term, but in the long run, it might prevent you from losing a fortune in court fees and court damages. Intellectual property is not something to be taken lightly, but when you do it right, it can help you build a stronger brand and give you an edge over your competition. And isn't that what you really want?